Well, there appears to be trouble on the chalkboard, so this must be the court gallery. What do you mean, Marty? Of course it must. Mustn't it be? Because it is the court gallery, ladies and gentlemen. Welcome to another evening of court cases where we're going to review some of the more interesting, in my opinion, court cases of the day. We're only focusing on two dockets today, ladies and gentlemen, because, well, to be quite honest, two of the court cases we're going to review tonight are fairly lengthy. The first docket set we're going to take a look at is obviously Judge Webster. She had a traffic docket today, and I just don't understand how Kansas traffic dockets can become so frustratingly complicated. But they do. And we have at least one trucker who insists that his big rig has a governor on it, and there's absolutely no physical way that he could be doing the speeds purported by the ticket that he got. And ladies and gentlemen, he's going to argue about it, and we're going to watch it. And then after that, we're going to check in with Judge Middleton, who has the first of two very troubling landlord-tenant cases. And this one involves a long-standing dispute between two parties and a very upset pro se plaintiff, defendant. I'm not sure which it is, but it all starts right now.
You're here on Matthew Castor, is that correct?
No, ma'am, this is Victor Miller.
Well, is Mr. Oswald?
That's correct, Your Honor.
Who is your client?
Matthew Castor.
And is he here today?
My understanding is he was in custody. I thought he was going to be here and brought in.
All right, Missy, do you know where he's in custody?
In Greenwood County. He was transferred from Reno County to Greenwood yesterday.
Yeah, I don't know. I'm currently on the phone with Mr. Kirkman. He's trying to get in our hearing for the bond forfeiture, but let me see what I can do, see if I can get him on. I didn't know for sure if he'd been transferred here.
I'm here as well. Sorry, I had to step away from him. And Richard, that agreement's fine. Actually, the second count was what Ms. Gillette had put down was it was to be, instead of the offense you referenced, amend count 2 to no DL.
Okay.
I don't think that would.
No, that's fine. Yep.
Would one of you say that again, please, what your agreement was?
Your Honor, I have a email that Miss Gillette has made the following offer to Mr. Castor that he to amended count 1, interference with a law enforcement officer, be 6 months with a recommended 6 months underlying sentence, and based upon your client's lack of criminal history, Richard, I'll be recommending 12 months non-reporting probation.
Okay.
Count 2 will be amended.
You're amending failure to stop in an accident to, what was it?
Interference with an LEO.
All right.
And then amend count 2 to a no DL with a $100 fine and court cost booking fee.
Any jail time?
And the standard. Oh, and yes, 6 months underlying.
On each. Did you have a fine recommendation on the interference with Leo?
Miss Gillette did not this is Miss Gillette's offer, and it did not contain a fine on count 1, just count 2, the traffic offense.
Mr. Dean, the amended statute that the count 2 is being amended to, was that 244 or 235?
235.
Thank you.
And then
The failure to stop at an accident is amended to interference with law enforcement, and failure to use ignition interlock device is amended to no driver's license in possession.
correct, Your Honor. And factual basis on the amend count 1 is that the individual.
Yeah, we're not on the record yet, so.
Right, but just so the court's aware, basically what, from speaking with Miss Gillette, what she's, because I'm not even, this file wasn't sent with me. She advised that the state would be relying on a proffer that essentially the defendant in this particular case, after the accident, went and hid out in some trees and then finally came back to the accident. So.
Mr. Dean, again, you said on count 2, you said that was 244 is no deal on person, is it not?
Correct. 8235, your client's license is expired, so he doesn't have a license.
And we're going with 8235?
Yeah, it says no deal is what the offer is. I mean, I'm just conveying what Ms. Gillette put in an email to me. So no DL to me is 8235.
Okay. It's like a pretty sweet deal.
I would take it.
Yeah. If I were in his shoes, I would.
Yep.
I'm not saying I need to take it. I'm just saying I would take it. If
I have talked to Mr. Castor on this. Did get a chance to visit with him yesterday, and told him what was offered. He expressed his desire to take the deal.
Are we just trying to get him to Zoom from the jail?
Yeah. And I trust these are no contest, please, since you're telling me about a factual basis.
Yeah, no contest, Your Honor.
Let me get this. I was in the process of looking up that citation for the interference.
Well, while they're trying to get him here, Mr. McClendon, do you want to take up one of yours?
I'd like to talk to Mr. Dean first, if you don't mind.
This might be a good time to do that. Mr. Dean and Mr. McClendon, can you put them in a breakout room, Missy? Is this Matthew Castor in the jail?
I'm going to bet that is.
Yes.
All right. We will be on the record now in GW 2026 TR 27, State of Kansas versus Matthew Ray Castor. Please announce appearances.
State of Kansas appears bonds for Assistant County Attorney Paul E. Dean.
Richard Oswald, Your Honor, attorney for defendant Matthew Castor.
And Mr. Castor has been added to the docket today on failure to stop at an accident with injury or damage over $1,000, a Class A misdemeanor person misdemeanor. And count 2, driving in violation of ignition interlock device as required following a DUI. This is a Class A non-person misdemeanor, but I understand the state is moving to amend those charges.
Oh, that's correct, Your Honor. The state would have moved to amend count 1 to move to interference with a law enforcement officer, violation of KSA 21-5904, as well as amend count 2 to no deal, a violation of 8-235, The state would be recommending that there be a 6-month underlying sentence for count 1, and with 12 months of non-reporting probation with the standard conditions of keeping the county attorney's office notified if you change addresses. Likewise, have no law violations and pay all the fines and costs within the time established by the court. There was no fine recommended on count 1 by the state. Obviously, the court has the final say in regard to that. As to count 1, the recommended fine is agreed is $100 with court costs of $108. Well, I guess, Your Honor, that would be a criminal case. So do we do is it 150? I guess. So sold them on this docket. All of a sudden, is that 158?
It's filed under traffic number.
All right. If it's still filed
But
under
if
traffic
she's
number,
amending it to no DL, I'm not sure how the clerk will. Well,
I'm
it's
just
still
going to go
traffic.
ahead and stay with the traffic because that's what our case designation is. Recommend 108 court costs, $45 booking processing fee. And that would be since the no DL is just an unclassified or Class C, there wasn't a recommendation in the plea by Ms. Gillette as to an underlying sentence, so I won't be making one. I think the 6 months underlined for count 1 is sufficient in this case.
Well, okay, 8-240, I believe, is an unclassified or C.
Oh,
8-235 is an A or a B. I'd have to look that
it's a
up.
B, Your Honor.
Yeah.
My apologies on that.
So you think it's a B?
Yeah.
8-dash. A B. 8-235 violation is a B. And you're amending to 8-235, correct?
Yes, Your Honor.
Right, so that is a B, and your recommendation, I think you said previously 6 months on each count. Are you recommending concurrent or consecutive?
Concurrent.
Concurrent, all right. Mr. Oswald, is that consistent with your understanding and agreement?
Yes, Your Honor. With Ms. Gillette, we didn't talk about any underlying on count 2, but that's certainly agreeable with us, as stated by the prosecutor.
All right, well then, Mr. Castor, is that your understanding of the agreement?
Yes, ma'am.
How do you plead then to count 1, failure? Well, it would be, how do you plead to count 1 as amended, interference with the law enforcement officer?
Your Honor, I think my client, we had not previously, we talked about pleading. We didn't talk about how pleading. Matt, you can either plead guilty or no contest. My suggestion would probably be no contest based on the discussion with the judge and the prosecutor.
Yes, sir.
So how do you plead?
No contest.
How do you plead to amended count 2, driving without your license in possession?
No
I'm
contest.
sorry, strike that. How do you plead to driving without a valid license?
No contest, ma'am.
Right, by pleading no contest, do you mean that you're not going to admit either charge, but you don't want to deny them and take them to trial?
Yes, ma'am.
Do you understand, even though you're not admitting these charges, you'll most likely be found guilty if the state can offer a factual basis, and will proceed with sentencing today?
Yes, ma'am.
Is anyone making you enter these pleas of no contest today by any threats or promises other than the plea agreement we've heard about?
No, ma'am.
Now, is anyone forcing you to do this?
No, ma'am.
All right, and Mr. Dean, you said something previously about
Your Honor.
factual basis.
Yes, unfortunately, none of that was provided to me in writing. My understanding, Your Honor, is the factual basis would be this: that following an accident, which law enforcement was notified by OnStar that Mr. Castor would have been alleged to have left the scene, hidden in the woods near the crash site when he had a duty to remain, thereby interfering with law enforcement's investigation when they arrived, and only after they arrived and had been investigating for some time did Mr. Castor return back to the scene of the accident.
And he did not have a valid driver's license.
And yes, at the time, his driving privileges were expired, therefore he had no deal.
All right, I do accept the defendant's pleas of no contest to counts 1 and 2 as amended, as freely and voluntarily given. I find the state has provided a factual basis in support of those non-contest pleas and do find the defendant guilty of both amended count 1, violation of KSA 21-5904 and KSA 8-235. I will follow the plea agreement for sentencing. At this time, Mr. Castor, on count 1, you are given no fine, but is ordered to serve a 6-month suspended jail sentence. On count 2, a concurrent 6 months jail sentence suspended. In this case, you'll pay a $100 fine, $108 court costs, or $158, whatever the clerk determines that to be. You will be ordered to pay court costs, and you'll be ordered to pay a $45 booking fee. And on that 5904, even though there's no fine, I'm going to order you pay a booking fee of $108 and a $45 court costs and $45 booking fee.
I thought I am unmuted.
Whoever's on a phone that is identified as 1-316-323-0056, you need to mute. You're interfering with this hearing.
And I would agree with that and order that. All right, now then, how much time is it going to take you to pay the amounts owed in these cases?
What's the total amount, ma'am?
Well, on the one case, it would be 108 plus 45, which would be about 153. And then on the other case, there add to that a fine of, it'd be about 253. So 253 on one, if my math is right, and 153 on the other, which is about 406 total.
I could for sure have it paid off Friday. Maybe today. I don't know how much is in my bank account right now, but I'm probably right about the total amount.
All right, well, I'm going to give you 30 days to pay on each, and Missy, if you want to look up a 30-day pay or appear. You're going to, if you don't want to finish, you will get credit for any time you've already served against your sentence of 6 months. But if you don't want to serve the balance, make sure you do not violate your probation. For 12 months from today, you are on a non-reporting probation. You will not have to see a probation officer, but that makes you solely responsible for making sure you comply with that probation, which will have the following conditions. 1, violate no laws for the year. No jaywalking, no speeding, nothing.
Yes, ma'am.
Violate no laws. Keep the county attorney informed of any changes in address or phone number or contact information.
Yes, ma'am.
Pay all within the time that you were given.
Yes, ma'am.
Anything else, Mr. Dean or Mr. Oswald, that I didn't mention?
I don't believe so, Your Honor. I do have a question. You assessed a fine of $100 on count 2, the no driver's license. I missed whether or not you went ahead and assessed a fine on count 1.
I did not.
Okay, all right.
But I did do the booking fee and the.
Yes.
I had just to be clear on the record, I just think the state said that at count 2 that the license was expired. I believe he was required to drive with the ignition interlock. So I guess technically his license was, invalid, obviously, for driving without the ignition interlock. But just I think the record shows that he was required to drive with the ignition interlock. I just want to make sure the court was aware of that in taking the plea.
I did hear you counsel discussing that before we went on the record, but thank you for making the record.
Thank you.
Thank you, Mr. Oswald.
Yeah.
All right, if there's nothing further.
Did you want to pay or appear date?
Yes, please.
Yes, please.
March 13th at 11.
March 13th 11 a.m. by Zoom. Now, you must either have it paid in full on these counts or be back here at that time, sir.
Yes, ma'am.
If you don't have one or the other done, then you're going to be looking at the bench warrant. And
Okay, yes, ma'am.
a bond, and here we go again.
Your Honor, did you give a notice of appeal rights?
Did I what? I'm sorry.
Provide him with notice of appeal.
Oh, did you say notice of appeal?
Yes, I didn't.
Well, I thought
All right.
with it being pleas, he probably wouldn't have that same right.
And correct. But he would have noted right to appeal
Right,
the
to appeal
sentence
the
within
sentence.
14 days if you thought
Yeah,
the
sure.
sentence was an error. Mr. Oswald, I'm going to show you this journal entry because I think if I can go ahead and get it submitted and you approve it, that is, then we can get your client out of jail. So we just got the case caption, case number, obviously the date we were here. It's your retained counsel. That there was a plea of no contest that was entered. Kind of need to make a reference to the factual basis accepted by the court. We have guilty on the 2 amended counts, interference, and citation that you provided earlier, as well as the 8235 for no driver's license. 6 months on count 1, 6 months on count 2. Counts 1 and 2 shall run concurrent. Pay all fines and costs within 30 days. 12 months non-reporting probation. Court costs of 108. I believe the court said, or as determined by the clerk of the court, if we are in error on that. That way we don't have to come back and do a non-pro-tunc. $45 booking and processing fee. $100 fine on, that should be count 2. On count $100 fine on count 2. Conditions of non-reporting probation, pay costs and fines within 30 days. If you have not pay or done so, reappear via Zoom on March 13th at 11 a.m.
Okay. Was there 6 months underlying on both? 6 months underlying on both of these?
Yes, concurrent.
Okay, that's great.
That was right here.
Client pled no contest, not guilty. That's the only thing that I think you'd mentioned. The guilty plea was a no contest plea.
I marked it no contest.
Okay, I thought you said guilty. Okay. Yes, that's.
Then on the last one, keep county attorney's office notified change addresses, no law violations, and then I'm going to make a reference that the court accepted the factual basis offered by the parties.
Yep, that sounds correct.
Then we can get that approved by the court. Get your client over.
Yep, have authorization to file that.
And I'm sorry, Mr. Dean, I didn't know. Did you put credit for time served in there?
No, I'll make a reference to that.
I don't know how much time you served, but it will count against your sentence, but hopefully you won't have to worry about that. You won't be violated. You won't come back.
No, ma'am.
Make your payments through the clerk of the district court, and if you stop by there, they can tell you the different means on how to pay. So you can pay online.
Okay, cool.
Okay. Well,
Thank you, Your Honor. Thank you, Mr. Dean.
Thank you, sir. Good luck to you, Mr. Castro.
Thank you.
Mr. Oswald, you're excused. Mr. Castro, you're remanded to the jail to do whatever you need to finish booking out there.
Thank you, Judge.
Yes, ma'am. Thank you, Judge.
So do I need to hold him until I get the journal entry?
I don't think so.
Okay.
Thank you.
You're welcome. I don't think you usually do. Don't you just usually let him go?
Well, usually we have the journal entry before I let them go, typically.
Well, why don't you check with your administrator and see what your administration wants?
Okay.
But you're gonna get this sometime today because we'll have it uploaded to you before noon.
Yeah.
Okay.
I'll have it out of my office before noon. I'm gonna actually go give it to my assistant right now and have her go ahead and email it down to the county attorney's office so it can be uploaded.
Great.
All right. Thank you.
Thank you, sir.
Thank you.
Judge,
Yes.
I wanted to let you know on the phone is Mr. Kirkman for the bond forfeiture. I was on the phone with him for a good 15, 20 minutes trying to get him connected and he was having problems. So I just gave him the phone number to call.
All right. And which person is he here for?
Riley Miller, I think.
Yes.
Let's call that one when Mr. Dean is ready for it.
I am ready. Right.
We are on the record in GW 2023 TR 365. You said this is Victor Miller, State of Kansas versus Victor M. Miller. Is that the one you said you're here for, Mr.
Riley
President?
Miller. Riley Miller, Your Honor, I believe.
Okay, let me change my numbers. All right, strike what I just said about the case number. We are on the record in GW 2025 TR 501.
Yes.
State of Kansas versus Riley Jocelyn Miller. Holly Dean for the state. Miss Miller, are you present? I'm looking for Riley Jocelyn Miller, who does not appear, nor does her attorney Marcus Blake Cooper, but I understand her bondsman appears by phone. Is that Don Kirkman on here?
Yes.
All right, Mr. Kirkman, this is a motion or a hearing on the motion for bond forfeiture. What can you tell us about Miss Riley Miller's whereabouts?
Okay. First off, Your Honor, I talked to her a couple days ago, and actually I misinformed her. I told her to get a hold of the clerk's office and get a Zoom link. I didn't know that she couldn't do it by Zoom until yesterday when the county attorney told me she had to be in person. Her father called me early this morning, told me that her mother thinks that she is an attorney, knows the law, told her not to go to court because I'd lied to her. I had actually told her I would ask to have her bond reinstated if she came to court. But her mother told her I was lying to her, that she was just going to go to jail. So what I want to ask of the court is that you go ahead and grant judgment on the bond. And I'm asking you if you will give me 30 days to get her picked up and in court and put her in no bond hold on her or something.
Well, what does the state have to say to that?
Judge, here's what I would recommend. Appreciate Mr. Kirkman's position, but I think it may be a little easier if we just grant Mr. Kirkman a 30-day continuance of this matter. Reset it for review at that point in time. And I would move at this point then, based upon Mr. Kirkman's information, to amend the current bench warrant from 5,000 cash or surety to a no bond hold.
All right, well, I show the defendant was ordered to appear on her bond at a previous date and that she did fail to appear. Both she and the bondsman were given notice by certified mail. The defendant apparently refused hers according to the return. And now we've been updated by Mr. Kirkman. I would be inclined to follow the recommendations of the state, but Mr. Kirkman, if that's going to make a difference in how you proceed, I can sure follow your recommendation, which is
I mean, if there's a reason to go ahead and grant judgment, if he's going to get her in here in 30 days, to me, it's just like then we'd have to set the judgment. Mr. Kirkman, I'm assuming you will be wanting to not pay that judgment and ask to set it aside then at that point in time.
That would be correct, and I'm definitely going to go get her.
Well, is there any advantage to you to order one way or the other, Mr. Kirkman? The options would be to just grant you a continuance and not take judgment at this time, and then come back in 30 days to see if you have her. If you don't, then we'd take judgment. Or, now that's my understanding of Mr. Dean's recommendations. My understanding is, or do it the other way, grant the judgment, but withhold enforcement for 30 days. You're still getting 30 days. One way you take a judgment, one way you don't. Do you have a preference or a benefit?
But then if the judgment is granted, even if I do pick her up and bring her in, do I have to come to court again to get that judgment set aside?
Well, typically, that's why if there's no benefit to your position by having a judgment granted, then I would recommend what you just agreed that we'll continue this out for 30 days or modifying the bond, or I believe the court's going to modify the bond to a no bond hold until you see the court. And I believe once you deliver her to the jail, you can probably ask the court to, you're not going to be willing to reinstate that bond. So until the case is resolved or the court issues her a new bond.
Yeah, Your Honor, I think that I'd be smart to go with Mr. Dean's recommendation.
All right. So, I'm going to make this at the joint request of the bondsman and the county attorney to continue this about 30 days out to determine the bond issues. But I will modify bond. The new bond will be a no bond hold. So, Missy, what do you have about 30 days out for a continuance of the bench or of the
March 13th at 9 a.m.
All right, we'll give you till March 13th, 9 a.m. That's more than a little more than 30, so hopefully you can find her and get her back here.
At 9 o'clock.
And obviously, if you've delivered her to the jail, you don't need to appear, Mr. Kirkman. Would there be a reason in your mind, Your Honor, for him to appear?
No?
Okay.
All right, thank you, Mr. Kirkman. You are excused at this time and we'll be in recess on Riley Joslyn Miller.
Thank you. Next court, I'll be there in person. Thank you, Your Honor.
You can always come in person and avoid that telephone Zoom issue.
Thank you very much. Both you and Mr. Dean both.
You're welcome, Mr. Kirkman. Good luck.
Thank you.
Thank you.
You're welcome. Mr. Leonard, we are not to be smoking in court, even though we're not in session. The YouTube prohibits smoking on screen, please. So either black your screen or don't smoke. Thank you.
Well, I'd say let's call this. We've got both officers here, Phillips being the primary. If I've got that correct.
All right, we are on the record in the 13th Judicial District, District Court of Greenwood, County, Kansas. This matter comes on for conclusion of bench trial in GW 2025 TR 303, State of Kansas versus Robert Lawrence Leonard. Please announce appearances.
State of Kansas appeared by Massachusetts County Attorney.
Defendant Robert Leonard appears in person by his attorney, John Barrett.
As I said, this is a continuation of the bench trial, which commenced January 30th, 2026. We were all parties present as now, and state's witnesses, Troopers Scott and Phillips, were present. We'd gotten into the trial, if my memory serves. It's not noted in the docket, but it was continued for discovery of the officer and the radar certification to today's date. So, Mr. Dean, where do you want to start this hearing?
Your Honor, actually, I believe when we were getting ready to open the proceed with opening statements is when the discovery issue arose. So I don't think we'd actually called or sworn anybody at that point in time.
I believe that's right.
And continued it there. So at this time, the state would waive opening statements and let Mr. Barrett make any if he wants to, or I'll proceed.
I'd waive opening.
Trooper. Sorry, Your Honor. I call Trooper Phillips to the stand if the court's ready.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you. Please proceed.
Trooper Phillips, would you please state your full name and title for the record?
Trooper J.D. Phillips with the Kansas Highway Patrol.
And how long have you been with the Kansas Highway Patrol, sir?
17 years.
And I take it that by being with Kansas Highway Patrol that you completed the Highway Patrol Academy?
Yes, I did.
And prior to that, and I take it you completed it successfully.
Yes, a 22-week course.
I'm assuming if you don't complete it successfully, you can't be a member of the Kansas Highway Patrol. Would that be accurate?
That's correct.
28 years I've never asked that question, if you could fail the course and still be a patrolman. But anyway, prior to joining the Highway Patrol, were you previously a certified law enforcement officer with this or another jurisdiction?
No.
Okay, so when you through your training through the Highway Patrol Academy, were you trained in basically the operation of any type of radar device regarding speed interdiction or any other methods in regards to detecting those violating the posted speed limits?
Yes, in the academy, there's a 2-day course followed by our field training of 77 days.
And you say field training of 77 days. What does that amount to?
Field training is riding with a training officer and operating the equipment, learning how to use the equipment, and then enforce the traffic laws for speed.
And I would assume it does, but could you tell me, is there continuing education on these topics for you or provided to you over the years that you've served with the Kansas Highway Patrol?
There's a radar certification requirement to get certified to use the equipment, and that happens after FTO or during the end part of it. The field training officer transfers you over to the radar certifier. You get certified on the equipment, and after you're certified, that's indefinite from that point of being certified.
Oh.
And Your Honor, we would, because they have provided the certificate, we'd stipulate that he is certified on the radar unit.
And then the radar unit itself, and the tuning forks, do they receive some type of certification?
The manufacturer does the certification on the equipment.
All right. And you've provided that certificate as well? Yes, I have.
And just identify to make sure that those are the tuning forks and the units that the certificates were provided for. Get that will stipulate as to that part.
Officer, can do you see a certificate of accuracy on the screen?
Yes, that's for my stalker radar unit.
And you don't maintain certificates for any other devices that you're not deploying in the field, correct?
Yes, that's the right one.
And that's so just for the clarity of the record, that this is a certificate for the tuning forks and the stalker device that you deployed on July 3rd of 2025 in Greenwood County, Kansas, in association with your traffic stop of Robert Leonard.
Yes, it is.
Your Honor, I guess for the record, I would mark this as State's Exhibit 1 and ask the court to admit.
I understand there's no objection to admission of this.
Correct, Your Honor, there's no objection.
Stipulation, very well, that is so admitted.
All right. Now, back on that particular day, officer, what were your duties?
I was patrolling in Greenwood County.
And did you have occasion to make contact with a vehicle at approximately Highway 400 at mile marker 325 East?
Yes, I did.
What was it that drew your attention to that vehicle?
I was traveling westbound on U400. I observed a truck tractor. It was white in color coming at me. In the front antenna, I checked its speed at 80 miles per hour. The vehicle speed looked like it was going 80 miles per hour. I estimated speed, tracked its speed. That stayed in the target window until it left. The tone dropped from 80 as soon as I met that vehicle. I activated my rear antenna before I entered the target window. And as soon as that truck tractor entered the rear antenna, I tracked its speed also at 80 miles per hour as it was moving away from me. I turned around and started catching up to the vehicle, and I checked its speed again with the front antenna in the same lane at 75 miles per hour in a 65 mile an hour posted zone.
And this was a 65 mile per hour posted zone for the entire description of what you just gave to the court, as far
Yes,
as
it is.
taking the first radar reading of 80.
Yes, it is.
And all right. So after obtaining those readings, what did you then do?
I initiated a traffic stop on U400.
And did you make contact with the driver?
Yes, I did. His name was Robert Leonard.
And do you see the driver with us here today?
Yes, wearing glasses, dark blue shirt, and then the screen says Robert Leonard.
And were you able to identify Mr. Leonard via driver's license?
He provided a Texas CDL Class A license.
After you made that initial contact and obtained his driver's license and other pertinent papers, what did you then do?
I made contact with him, advised him why I was stopping him for his speed. I told him that his speed was 80 and a 65. He said his truck was governed at 75. And then when I asked him why he was driving over the speed limit, he said he was trying to keep up with other traffic.
Did you have any further discussions with him regarding the purpose of your stop?
I explained the speed and then how his speed was the highest in that area. And then I initiated a citation for the violation.
You stated the speed was the highest in that area. What do you mean by that statement?
I was checking other traffic in the area of him. There was vehicles in front of him as well as behind him, and his speed was greater than their speed.
So that'll go to a question that I'm sure you'd be asked if I don't ask it. How is it that you're able to differentiate between Mr. Leonard traveling at 80 miles per hour versus picking up a reading on some other vehicle that happened to be traveling in the same area?
Part of our radar certification is speed estimations. We estimate the speeds and watch vehicles, track their movements, estimate their speeds, and then we corroborate that with the radar unit itself and the tone that it gives, the Doppler tone, as well as the reading that it produces on the screen. And this day I was tracking vehicles before him in the speed range of about 70 to 75 miles per hour. There was one vehicle that was 78, and then that vehicle left the target window, and then there was a gap between those vehicles until Mr. Leonard's. Mr. Leonard's vehicle was at 80. It stayed at 80 the entire time I was tracking it till it closed to me. And then the rear antenna was also tracking that other vehicle at a slower speed. When Mr. Leonard's vehicle entered that target window on the rear antenna, just as soon as we met, it went back to 80, and his visual estimation of speed did not change.
And in regards to, and what type of training do you do to basically be able to make that visual estimation of speed?
We're trained in the training process of radar certification to see vehicles and estimate their speed. It's a practice that takes repetition, but it's repetitive, and you visually look at those vehicles moving and estimate their speed by your observation.
You indicated the tone. Does the tone also help essentially identify which vehicle you're actually tracking as that tone gets stronger as that vehicle comes closer, to my understanding? Is that correct?
There's a Doppler tone that's produced, yes, and that tone is going to be changing, varying by their speed. So a different vehicle speed will make a different tone. And that vehicle's tone was that which was also indicative of 80 miles per hour.
One question I should have asked you, do you have a particular habit or custom as far as checking your radar device on a daily basis before deploying it?
Yes, daily we check it at the beginning and end of the shift. There's a power on test and an internal circuit test that was completed, and the instrument was working properly.
And you also generally use your tuning fork test as well.
In July of 2024, the agency changed its rules not to use the tuning forks as daily testing, and then as well as the manufacturer's recommendation. So based on the manufacturer's recommendation and our policy changing, we've just started doing the power on and internal circuit test, the two tests.
And if it had failed that test that day, what would you have done?
The unit's removed from service until it can be maintained.
I assume at this point in time, you simply issued Mr. Leonard a citation for exceeding the maximum posted speed limit and released him?
Yes, he was cited there at the milepost that we stopped him at, and he was released.
And all of your radar readings and the location of the stop, were they all within the confines of the corporate limits of Greenwood County, Kansas?
Yes, they are.
And we have Trooper Scott with us today. Was she a trooper in training with you at that time?
She was riding that day, yes, and observing.
All right. Did she take any action in regards to this case other than make observations of how you handled the matter?
No, just as a witness to see the traffic stop.
Thank you, Your Honor. I don't have any further questions at this time.
All right, cross-examination, Mr. Barrett.
Yeah. What was the prior reason for having the tuning forks?
The manufacturer issues the tuning forks with the radar unit.
And what was the purpose for using those?
The manufacturer uses those as a 25 and 40 mile an hour test.
And how does that work?
The tuning forks are to put in front of the radar unit, and the signal that's sent off of that will read the speed that's they're indicated for, stamped for.
So you strike the one for 20 miles an hour, and it produces a reading of 20 miles an hour on the radar unit, and you do the one for 40, and it produces a reading of 40.
25 and 40, yes.
Or 25 and 40, I'm sorry. Okay. And that has been discontinued?
July of 2024, our policy changed, and the manufacturer's indication was before that.
Okay. So other than an internal check on a machine that looks like it was about 5 years old when this occurred, you don't have any thing to show the accuracy of the unit. Is that correct?
My unit gets checked. We do triannual radar recertifications. We call it recertifications of the units. I'm a radar recertifier, so every year I'm going out in every patrol unit in my area of jurisdiction. I'm checking their units against the unit that's in my vehicle. So their units are going to be checked triannually every 3 years, but I'm the one doing that. So every year I'm checking everybody's radar units in our troop. So every year I'm going out and comparing my speeds with their speeds and using our radar to do
When
that.
would the last time have been that you did that?
I usually do them between January and March every year. So it'd have been January, March of each year that I've done that.
Okay. Yeah, so if the other units were off, then there's no real guarantee that yours would not be off as well.
The certification checks the equipment and they're all working properly. And
So you said the certification was to check them against your unit.
all the units in the troop, yes.
Yeah. So if something would happen between March and, was this August, I believe?
July 3rd of
July 3rd, I'm sorry. July 3rd. So something happened in the somewhere between 4 and 6 months, then you're not going to know until the next time you check, and you don't know for sure that some environmental condition on that day, or just something would affect the reading.
No, I'm certain that the instrument was working properly. I checked it that day for its accuracy, and it is working properly.
Okay, you checked just by the internal check, though.
What the manufacturer recommends to do is a power on and then an internal circuit test, and those tests were completed, and it is working properly.
Okay, so you did the internal check, but there's no external to ensure that it was accurate on that day.
The procedures that I followed.
I think
Seems to have frozen up here.
seems to have frozen, yes.
Or a very pregnant pause.
Yeah.
It's normally a long one.
Showed that it is working properly.
Okay. Yeah, but there's no external test now.
The manufacturer does not require it, and the agency has taken it out because of that.
Okay. I don't believe I have any further questions, Your Honor.
Very well, Mr. Dean, any redirect?
I'll just briefly. Trooper, my recollection of your testimony was that you'd also done the visual estimation that was matching what your radar device was displaying, correct?
Yes, that's correct.
And then you did inquire of Mr. Leonard why he was exceeding the maximum posted speed limit.
Yes.
And he indicated he was trying to keep up with traffic?
Yes, he had indicated that he thought the speed limit was posted at 70, and I asked him why he was driving 10 to 15 miles per hour over the speed limit. His answer was he was trying to keep up with other traffic.
No further question, Your Honor.
Anything to follow up, Mr. Barrett? Recross?
Nothing further, Your Honor.
All right, any further witnesses, Mr. Dean?
Your Honor, I do have Trooper Scott here. I don't imagine she has anything to add beyond what Trooper Phillips said, so the state won't call her, but obviously if the defense would like to, she's here and available.
I think, Your Honor, that no matter, she's just going to corroborate her observations. So I don't think there's any need probably to have her testify.
All right, so the state rests, Mr. Dean?
State would rest, yes.
Mr. Barrett, any evidence?
Yeah, call Robert Leonard to the stand, please.
Mr. Leonard, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God?
So help me God.
You may lower your hand. Thank you, sir. And Mr. Barrett, you may proceed.
State your name and occupation for the court, please.
Leonard, I'm a truck driver.
How long have you been a truck driver?
Off and on for about 42 years.
Okay. When you say off and on, how long currently has it been continuous?
Well, let me see, since probably about 2002.
Okay. Yeah. When you're in your truck, have you developed the ability to estimate your speed without the speedometer?
Sometimes, yes. A lot of it depends on the area I'm in. If it's an open area or something like that, up and down hills, so forth.
Okay. Do you remember July 3rd of 2025?
Yes, sir, I do. I actually took notes on it.
Okay. Where were you on that day?
Well,
let's narrow it down to where were you at approximately 8:46 a.m.?
I was driving across Kansas going over to Sugar Creek, and I'll make a delivery over there.
Sugar Creek.
That's the name of a meat company over there in Kansas.
Okay. And what town is that in?
Oh, I can't even pronounce the name, honestly.
Okay.
It's kind of a long, wound out name, begins with an L.
Okay. Do you remember driving in Greenwood County?
Sure. Yes, sir.
Okay. You remember getting stopped by Trooper Phillips?
I do, absolutely.
Okay. Can you tell us what had happened, what you were doing at that point?
Well, like I said, told the officer that day, I was driving across there, pretty much just trying to keep up with traffic or maintaining roughly the same speed. I just had the two vehicles in front of me pass me coming up the hill that I was coming down, where he and I passed one another. There was another truck, semi. It was a day cab pulling a flatbed, and then there was a car right behind it. I don't know how fast they were going. All I know is that they passed me. Coming back down the hill and off from where I had previously had it set, we were on a 2-lane road. So I was trying to maintain roughly the same speed they were going so that people weren't having to pass me like on a 2-lane road.
Okay. When you saw the trooper, how fast were you going?
When I saw the trooper, I was doing 59. That was at the top of the hill where he pulled out from behind me. I never noticed him going by in the other direction.
Okay. How you say from the top of at the top of the hills where you saw him?
Yes, sir. When he came out from behind my tractor or behind the trailer, and he had his lights on, and I honestly thought he was going after the other two until he started, when I pulled over to get out of his way, and he started pulling in behind me. My first thing was that he was pulling me over to do a DOT. I believe I even stated that day.
Okay. Is there some reason that you believe that you were not going 80 miles an hour at the time?
Truck wouldn't do 80 miles an hour normally. The truck's governed at 75. The automatic transmission in those trucks, it's not the truck I normally drive, but the Cascadias have an automatic transmission. And they also have a brake system that's in those trucks. It's a Bendix brake system. Two things happen when you go over the speed and with that braking system. One is the engine brake applies at 2 miles an hour over. At 3 miles an hour, the braking system goes from a low setting to a high setting, which slows the truck down. It's an exhaust brake, or what we used to call a Jake brake. At 4 to 5 miles an hour over wherever you have your cruise set, or in this particular case, it would have definitely been the maximum speed of the truck, which is 75. The Bendix brake system should have applied, and which would have slowed the truck back down to the maximum speed that the truck would do, or where you had your cruise control set.
Where did you have your cruise control set that day?
73.
So the brake would initially then apply at what speed?
The original exhaust brake should have started at 75.
Okay. And then the stronger brake, I guess for a better term, would apply at what speed then?
74 to 75.
Okay.
It's just the way
did the brake apply?
Is set up on those trucks.
Excuse me?
It's just the way the computer system is set up on those trucks.
And did the brakes apply on that day?
It had the lighter engine brake was on, but it never went to the heavier engine brake. No.
Okay, and the heavier engine brake would have applied at what speed?
At 75, which would have been, well, the heavier engine brake would have come on about, would have been up to 76 is where the heavier engine brake would have come on. It's a noticeable difference in the sound.
Yeah. And you would have noticed if that had occurred.
Yes.
Did that happen any time in the, say, 5 miles before the officer stopped you?
No.
Did the your speedometer indicate that it was the brakes, automatic engine brakes were operating properly that day?
Well, anytime that I had used the engine brake beforehand, yes, they worked fine.
Okay, did it apply at any time during that day to where you would know that it was working properly at that time?
There's one hill back before, roughly where we got stopped. It's a little longer grade where, yeah, it did come on, but I had the my cruise set lower than what it was. I had the cruise set at 78 or 68. I'm sorry, at 68 miles per hour, and that's where I had readjusted it upwards to try and keep up with traffic better, so that I wouldn't have traffic blowing by me. First off, I figured it was a little bit safer for me and anybody else on the road. It's a 2-lane road in there, and people trying to pass you on a 2-lane road a lot of times don't pay attention. I didn't want to have a wreck over there beside me or right in front of me where I wound up running over everybody.
And when it applied, did you check the speedometer to see if it was being applied at the appropriate speed?
The highest speed I saw on my speedometer, I think it was 75.
That's the highest?
That's the highest I noticed on the speedometer.
Would you have been watching the speedometer in that area?
If something had indicated I needed to be watching it, or if I had needed to apply the brakes myself, yes, I would have.
Okay. What would have happened to cause you to do that?
The engine brake would have gone over to a higher setting, or the Bendix brake system would have started braking me.
Okay. And your observations were that the braking system was working properly that day?
Yes, sir.
Okay. Yeah. How fast do you think, and you may have answered this, how fast is the highest have been that you would have driven in the, say, 5 miles before the officer stopped you?
I mean, I might have been doing 75. It's all the highest I had noticed. Like I said, I mean, traffic was passing me. I just picked up speed trying to keep up with them. The truck won't go but 75.
And had you gone over that, the braking system would have applied?
Excuse me?
Had you gone over 75, the brake system would have applied?
Yes.
And you would have noticed that?
Yes, sir. With where the cruise control was set, yes, sir. Definitely would have noticed.
Yeah. I don't have any further questions, Your Honor.
All right, Mr. Dean, cross-examination.
A few, Your Honor. Mr. Leonard, what was the age of this tractor or this tractor?
2025.
And you indicated that this isn't the truck that you normally drive.
No, it's not the truck I normally drive. My truck, which is the one I'm sitting in right now, was in the shop.
So is this basically a rental, a loaner by a company, or?
It's a company truck.
And when's the last time you'd operated that truck?
Good grief. I had been operating that truck for about a week.
And prior to that, had you ever operated that truck before?
No.
Who does the maintenance on that truck?
The shop.
You don't know specific individual or anything of that?
No, it would just be the company or Freightliner, because everything on that truck would be under warranty.
And things under warranty sometimes don't work properly, correct? Or we went warranties. Would that be accurate?
Absolutely.
Did you have any kind of independent testing done on that particular braking system to verify that it was performing as intended?
I hadn't had any reason to, no, sir.
Is there a delay time period in regards to that governing system as far as the various braking systems that you just described kicking in?
What do you mean a delay?
Is it as soon as you hit 75?
Yes, sir.
Is there an instantaneous reaction, or does it take a minute to apply?
It would depend on whether or not if you have your cruise control set at a lower speed, the braking system will start applying 2 miles an hour over the speed. That would be the delay, 2 miles an hour. For that particular truck, or any of the newer trucks, as far as I'm aware, the Cascadias, when you govern that truck to a certain speed, you have no control over, as far as you can't go any faster. As far as you yourself, you cannot make that truck go faster. If you were coming down a long grade or something like that, if you were coming down a grade that's 1.5 miles, 2 miles long at a 4% grade, the truck, of course, is going to try to pick up speed if you're loaded. And yes, I was loaded that day. I had about 44,500 pounds in the trailer. That's why I know that it picked up a little bit of speed. Of course, the brake started applying, and which wasn't the Bendix brake system, it was engine brake. At certain speeds, certain parts of the braking system will engage on the truck.
So going down grade, it is possible to pick up speed, in, according to your testimony, in excess of the governor.
Sure, it is. But again, the braking system would start applying.
And you were loaded.
Yes, sir.
Headed to Sugar Creek. Is that Frontenac, Kansas? That sound accurate?
Where now?
Frontenac, Kansas.
Okay, there you go. I'm glad you could pronounce it.
I grew up here, so actually played them in football in high school. So in any event, so you were going down grade because you said you were hit the crest of a hill when the trooper turned around, correct?
Yes, sir.
With 44,000 pounds?
Yeah, I had 40, I think it was about 44.5 is generally about what that load is. It puts us at about 79,000 pounds total.
And according to your testimony, you had your cruise set at 73.
Yes, sir.
I don't believe I have any further questions, Your Honor. Thank you.
And redirect Mr. Barrett.
How strong are the Bendix and the engine brake to keep you from going faster than that?
Well, the Bendix brake system is actually a part of your actual brakes, and I mean, you have your emergency brakes and you have your normal braking system. Your Bendix brakes is the type of brakes that you have on your truck. You also have an engine brake, and or what used to be called a Jake brake, though it's entirely different than what it used to be.
Yeah. Okay, so would it, when you're going downhill with that much of a load, would it stop you from going faster than what it than the 75 miles an hour that you said the truck was governed at?
Oh yeah, absolutely.
So going downhill is not going to make you go faster than what the governor is set at.
You could still go if you had your foot just on the pedal and you were doing 75 miles an hour, which would be the maximum the truck will go on its own, and you started going down that hill, the truck would start to try to pick up speed. the first thing that happens is the lower setting of the engine brake comes on. Then the heavier setting of the engine brake comes on. Then the Bendix brakes apply. So by 4 miles an hour over whatever the truck is governed at, your Bendix brake system should be, which means the absolute max that truck should be able to do is 79 miles an hour. That is the absolute max going down a grade.
Would you have noticed if they had applied that strongly?
Yeah, absolutely. I mean, if you have a newer vehicle, then you probably have that automatic brake system in your vehicle. It's like saying if you lost control of something and that brake system applied, would you notice your car putting on its brakes?
Okay. And did it get to the point of the Bendix brake applying?
No, sir.
And that is just going, say, 5 miles from where or 10 miles even from where you were stopped.
Yes, sir.
Just to make sure, yes, sir, it did not apply during that time.
No, it didn't. The braking system never applied like that. The lighter brake did. The lighter of the two engine brakes did come on, yes.
And did you notice it slowing you down going down the hill?
It never went up. I never saw it go over 75.
Would you have been watching to have seen that?
Yes. If it started going off anymore, yeah, I would have put the brakes on myself.
Okay. Yeah, just to make sure, you did say you had made some notes in about the whole incident, and did you refer to those notes prior to testifying today to make sure you were accurate on your testimony? Yeah, and I'm afraid that last what you said was not very clear. I couldn't quite understand what you said.
I'm sorry. Yes, I have them written down right here in front of me.
And you did refer to them to refresh your memory for your testimony today.
Absolutely.
Okay. No further questions, Your Honor.
Cross-examination, Mr. Dean?
Just one more area follow-up. Mr. Leonard, are you, as far as your role in the trucking business, has your role always been as a driver?
Pretty much. I used to own a small company. It's been quite a while back. I shut it down in 2008 when the economy started.
You're not a certified technician. You're not a certified technician as far as
no
maintaining and repairing or inspecting of these braking systems that you've been testifying about.
No, sir.
You've not taken any technical courses in regards to how those systems apply, their faults, their pluses, etc.
On the new braking systems, no. One of the things we have to know how to do is go out and inspect our brakes. So, I mean, as far as just going out and inspecting to see if their brakes are okay, yeah. But as far as all the electronics and stuff like that, the only thing I can do is go off of how the vehicle is acting or responding that day. I mean, it's kind of the same as anybody else that works with an electronic system. Unless you can build it or rebuild it or repair it yourself, you have to go off of what it does that day or the day before or what have you.
Thank you, Mr. Leonard. No further questions, Your Honor.
Mr. Barrett, last round.
We have nothing else, Your Honor. We would rest.
All right. Both sides resting. Do you have any rebuttal, Mr. Dean?
For Phillips, anything you want to add? Thank you. No further rebuttal, Your Honor.
Any closing arguments, counsel? You don't have to, but I'll give you.
I believe the court has the information the court needs to rule. The court wants me to address anything.
You know, I would just note that Mr. Leonard has testified that he knew he was going 75, but his truck was set so it really would not have gone faster than that. 75 miles an hour in a 65 in Kansas is, of course, a non-moving violation. So that becomes an issue. If it's 80, it's moving. If it's 75, it is not. And he was careful to note about what his cruise control was set at, what speed the brakes would apply at, and I know that the trooper indicated that the Kansas Highway Patrol no longer does the tuning fork test, but that really is the only way we really know that it is working, that the readings it gets are proper. We know that the internal electronics are okay, but without the tuning fork, we really don't know that there is not something going on that would keep it from actually giving the proper reading. So I asked the court to find the defendant not guilty. Certainly, if you want to find him guilty of 75, I think his testimony would support that. But do believe that not guilty beyond a reasonable doubt on 80.
Your Honor, I would just note in rebuttal to that there was no expert testimony regarding that no longer using the tuning forks diminishes the accuracy of the device.
Well, I have always understood from years of testimony, but focusing just on what I've heard today, that not only is the tuning fork test a valid test, but also the internal calibration is an accurate test too. So I find that there's no reason to believe the device was not working properly. The officer testified. Both witnesses come across as very knowledgeable, very credible. They both know the machines they use, it sounds like. But there is a test for the internal calibration, and the officer also is trained and tested to tell the accuracy of a vehicle, which often leads him to check the speed of a vehicle. In this case, he saw the Leonard vehicle, in his opinion, coming down in violation of the law, so he put his radar on it, and it confirmed his visual test. So he had two tests there, visual and radar. Mr. Leonard talks about how well he knows his braking system, and he certainly was credible on that as he explained it. He is not as knowledgeable as I find it of this particular truck and its system. He did not have any way of presenting testimony to show that it was working accurately, but the state didn't show that it wasn't either. I think if this were a truck that the defendant had used more often and could rely on, that would lend more to his testimony. It was a new truck. You know, as the trucks get older, their speedometers get loose and things go wrong. Well, this was a new truck, so it would have been more accurate, I think, than on the cruise and speedometer on an older vehicle might be. But a lot of the testimony of the defendant hinged upon the cruise control. The cruise control at 68, then it was set, and then he adjusted it to 73 because all the vehicles were passing him, and he testified that he believed he was going, I think he testified to this, I heard somewhere in there that he was going 75. He would admit he was going 75. And he talked about going a little faster than that as it related to the braking system. But I lean in favor of the radar gun and the officer's visual speed. And while both witnesses came across very knowledgeable and credible, I do not have a reasonable doubt that the defendant was going 80 and a 65 as he was going down the hill. So I will find the defendant guilty But the defendant, of course, has the right to appeal this 14 days to the Court of Appeals. The fine would have been less. If I looked it up to see what the fine would be, the fine would have been less, but at this rate, let's see, 80 miles per hour and a 65 is a $75 fine, and a 108 and a 75 would be 183 total. That is my finding at this time. Find guilty. And how much time do you need to pay that, sir, or appeal it? Let me give you 14 days to pay your appeal, or do you need more time to pay your appeal?
Is that a question for me? I'm sorry.
Yes. Do you want some time to pay that?
I can pay it now.
Well, do you want, I'll give you up to 14 days to pay your appeal. And if you do appeal, the appeal bond will be the total due of 183.
Okay.
We can
That'll
talk
be
about
cash.
whether you want to appeal it or not. Quite honestly, the process is expensive enough and time consuming enough. I doubt if you really want to.
Okay, well, I'll let you gentlemen decide that. And the payment is due, as I said, within 14 days, or the cash appeal bond of the same amount. And that's just that if the appeal goes against the defendant, money will be there and he'll not have to come up with it.
I will tell you, if you pay it now, you do waive your right to appeal.
Yes.
Judge, can we set this on that last, or Missy, that last date in February for just
All right.
pay or appeal?
Sure. We'll set a pay or appeal date to see whether you've paid.
February 27th at 11.
Say that again, February what? 27th
27th.
At 11 a.m.
at 11 a.m. All right. If you have not paid or appealed, you'll need to be back here at that time, sir.
All right. Thank you.
Thank
Thank
you.
you, sir.
If you want to give me a call, we can talk about that.
All right. Thank you.
Thank you.
Okay. Yeah.
Have a good day, Mr. Barrett. Good luck, Mr. Leonard, Trooper Phillips, Trooper Scott. Thank you for your appearance today.
Okay. Thank you. Thank you, Your Honor.
You're welcome.
I believe we're done. So
You may go.
thank you, Your Honor.
All right, our next matter is the ongoing saga of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. Mr. Robert Soltis is here for Rosemary Blair. Carla Bowers and Joseph O'Donnell are here by Zoom. This matter is embarrassingly old. The file number is 221864LT. Now we're in 2026. This is Mr. Soltis's motion for contempt for the defendant's neglecting or declining or refusing to pay the escrow fees, which I cut in half. He claims the property is essentially abandoned and asking for relief from the court. Mr. Soltis, what's your position here?
Well, my position is, unfortunately, Your Honor, we have to be back here again. And the court was kind enough to reduce the escrow from $2,000 to $1,000 back in May. June 11th is the order. And payments have not been made. And there's a number of payments that have been missed. And October, November, December, January, and February have not been paid, according to the records that I received from the county clerk. And Your Honor, we don't need to, I hate to have to come back here all the time for this. And you've been most generous. Meanwhile, up at Stutzman's office, we have another case. We have the counter complaint, and the counter complaint, I gave them request to admit, or request to produce and interrogatory.
Your Honor, is this relevant?
Yes, it is.
Back in
Go
November,
ahead.
we had to file a motion, and we heard that was heard on January 29th. Judge Stutzman adjourned the motion on the promise by Mr. O'Donnell that those interrogatories would be answered and I'd get the documents by at least February 6th, the next week. And of course, I did not. And as we sit here today, Your Honor, I still haven't. So we have to go back to see Judge Stutzman on March 11th. These folks just don't do anything that the court and court rules require. So, Your Honor, we're asking that they be held in contempt. Now, I've checked the escrow. According to my math, not counting what's been paid, and Miss Belair is $5,000. There's $13,571.48. Taxes for 2024 have never been paid, and it's obviously going to go into foreclosure. And that amount.
Now, I released $10,000 of the escrow, but that
Yes.
would have paid the 23 taxes?
Correct.
Okay.
Now, the 24 taxes are now delinquent. And the total, that amount is $9,459.82. In the meantime, obviously, 2025 taxes are due. And those are $8,373.16. And total taxes due are $17,823.98. And that is more than the escrow, actually. So I guess what I'd ask, Your Honor, is that we use the escrow for the 24 to avoid the house going into tax sale, and nobody wants that. And then order that Mr. O'Donnell and Ms. Bowers pay the 2025 taxes, which are now due. Of course, I'm asking for court's attorney's fees and costs because we have to keep filing these motions, and because they won't do what the court orders. Thank you.
Well, you also asked for possession of the premises.
I do,
This
Your
should
Honor.
not take this long. We got our case done in 23, I don't know, and then it got into the circuit court and it was delayed for a year. The delay has hurt everybody. It certainly hurt the O'Donnells. It certainly hurt Rosemary Blair, who's in her 80s. And the matter is unresolved. The house's circumstances unclear. And the delay has not been good for anybody. Counsel withdrew because he withdrew. Leave it at that. They didn't get new counsel. They're trying to navigate these difficult waters by themselves. It strained their relationship. And so are you also asking that Ms. Blair have possession of the house?
Yes, Your Honor. First of all, Ms. Bowers and Mr. O'Donnell haven't lived there, I guess, ever since you gave them possession, probably, and even before. The house is going, excuse my French, to pot. They're not taking care of it. It's deteriorating, and you know, it's obviously its value is diminishing by not having anybody in there taking care of the property. And so, yes, if they're not going to do what the court has ordered them to do by way of escrow and others and paying the taxes, then Miss Blair should be back in the house. That's my position.
Is anybody paying the utilities?
Your Honor, may I speak?
Yeah, I've been.
Yes.
Okay.
So
yeah,
let me
I mean,
ask this. Let me
Go
ask
ahead.
that question first. Mr. O'Donnell, do you know if utilities are being paid?
Yes, Your Honor, they've been paid every single month for both gas and electricity, and they state and they show that they're up to like 147 a month. So that house is
All right,
more
and
than
the
any other house.
utilities are paid by you?
They have been paid by Miss Blair in
No, they
occasion.
haven't.
No, absolutely not. I have paid them every month.
Just a minute.
No, that's not
We're not sitting around the kitchen table. We're at a
You're
court
right.
hearing, and so I'll give you a chance to speak. So, all right, who is paying the utilities?
I have been paying them.
Say that again?
I have been paying the gas and the electric every single month.
All right. Each month?
Every single month. They've been paid up to full. They've been paid this month.
All right. All right, Mr. O'Donnell, you wanted to speak. What do you want to say?
Well, I mean, regarding Mr. Solstice's just blatant misrepresentation of facts, I mean, this is the third time, Your Honor, he's done this. This is harassment. He, in his order to you for contempt, he said that we didn't pay May, June.
Could you speak more clearly into the, when you
Oh, I'm
turn your
sorry.
head
Oh,
up?
I'm sorry. Oh, I'm sorry, Your Honor. In his complaint under number 2, Mr. Solstice claims that we only made $1,000 payment in September of 2025, which he also told Judge Stutz, just trying to make us look bad. And then he says, count 3, May 25th we didn't pay, June we didn't pay, July we didn't pay, August we didn't pay, October we didn't pay, 8 months. Your Honor, I tried sending all this stuff to you, but I can't get it in the right PDF. I have the files from your paid July, June, July,
Your audio
August,
is very
September. I got
poor,
them all right here.
Mr. O'Donnell. So do you
I'm
contend
sorry.
that you paid all those escrow payments?
Up until like 3 months ago, yes, or 4 months ago, whatever it was. We paid the first 5,000 a month. We paid the first 5 months. I have the orders right here.
All right. So then November,
And
December,
then-
January, February haven't been made?
No, not since we lost Dan Hatch. Our heart in there, and then
Say that again?
Getting some. I said we lost our. Is there a way for me to turn up my volume?
Well,
We lost.
bandwidth
That's
is
when we
not
ran into our.
great.
Oh, okay. Well, that's when we lost Dan Hatch, and then Mr. Under that stuff, we just got our.
All right, you
discovery.
lost who? Dan Ash?
Hatch, our counsel, he withdrew.
Oh, yes, okay.
You let him
Daniel
go.
Hatch.
And then that's when the our hardship occurred, and we were scrambling to find somebody else to represent us in our circuit court case. And ever since then, we've been harassed by Mr. Solstice, where Judge Stutzman even gave us a 2-week relief and told us that he would give us another 2 weeks if we needed it, because he knew how much stuff I'm going through. I spent 40 hours this week, 30 hours last week, and I'm barely even into this, Your Honor. And now that I've found all this, I have a home inspection report from May 5th, right after you let us go back into that house after Rosemary got it for one winter and destroyed it, which cost $20,000 damage.
Again, I can't hear you very well. Your signal keeps cutting out.
We paid Miss Hawes $20,000 in damage the last time she got to watch the house for a winter. Every pipe froze. We had to cut out every wall, and we had to put in a new furnace because she had a faulty and a new water heater as well. And we have put so much money in this house. I also had a home inspection done on May 5th of 2023, right after you let us go back into the house. And that shows the condition of everything outside and everything else. That house now is in actual better condition than it was when she left it to us the last time after the winter. And we are there, and I'm there at least once every 2 weeks. And I did put in the dock this summer, and I was up there with my kids. And the house is crappy on the outside, but it was like that when we originally went to purchase it. The house is from the 80s, and they haven't done anything. I mean, it's lipstick on a pig. But I spoke with the couple realtors, and they said there's no value really in the home anymore because it's stigmatized. Because Miss Blair has put this thing on the market, I called 2 different realtors that she'd already used. They're all like, no way we're touching that property. She's used every realtor here in town, relisted it, and she's been pulling this grift forever. And then they told me that the neighbors, Fishman, just put up a huge house that basically, almost blocks half the view, which, so for us to maintain possession, for her to get back possession would be ridiculous. But for her to even ask for that after the damage she did last time, and then, Your Honor, I don't know if you can hear me, but I tried emailing this to you. I don't know if it came through, but I had an exhibit thing for you guys that has basically she has right now $180,000 on this property currently owed. 170 or 54,000, I believe, of it is a federal income tax lien, and the other one, the state lien, is for like 40-some thousand dollars. And the title company that I had pull this, we were just going to try to get financing, maybe work a deal where we could just close this out. So there's no way that you could even close on this property until she takes care of that. So the property taxes at this point aren't the big issue. It's not going to be foreclosed on in the near, like right now. However, her income taxes, we can't, the title is just dead without her income or their personal income taxes being done. And then, Your Honor, can you hear me? I have just one more thing, Your Honor. Are you there?
Barely.
Okay. And then my last thing is that us being called in here today again and having to go through this is we just found out new discovery like last week that Doug Coleman, who was the original guy that Rosemary conspired with to like condemn us, kick us out. There was FOIA things that they hid for a while that just were released. We found on the Fabius Township thing, and our name was in there. And Doug Coleman last year in May went to the village attorney trying to have us condemned and kicked out again for sequestering an order or something to get us kicked out.
I'm not aware of that.
He's out of control. It's in. I can send you a copy of the FOIA, and he made several. So I mean, so there's something to know about that. So I wanted to make sure that that's not.
You sound like Charlie Brown's teacher. I get about every fourth word. It's you've got not much bandwidth, and so it's hard to hear everything. I was.
Can I try from my phone, Your Honor?
Excuse me?
Can I try to log in from my phone real quick? See if I can get a better signal?
Yes, you can. We might get feedback if you're logged in from two different devices.
Your Honor, are you able to?
Can you hear us, Your Honor?
All right, let's bring them in, see if we can hear it. We might get a feedback.
Your Honor, do you have me in a breakout room?
No, I don't. I have you in my room. I can hear you better now that your phone is on. So let's try this method. I can see you and your phone. I think I'm hearing you through your phone. So you were talking about.
I was at the point where in this motion, I was discussing Miss Blair the last time she took possession and how it caused us almost $20,000 in damage for the 6 months or 8 months she was watching it over the winter.
Now that was the winter of 23.
Yep, because it was May of 23 when we got back in there and I had the home inspection done.
All right.
And
so
he detailed everything, but I also for our hardship, I mean, we lost, Dan Hatch here, and Mr. Solstice keeps on referring to us missing these deadlines and this and that. We didn't receive until our discovery from Butzel until this Monday that I had access to, and then the next day we received I have to be in Grand Rapids next week because they're going to put liens against all my stuff, which of course, Butzel swore to us that this unlosable case, and they swore to us that they'd wait till after.
All right, so you're also being sued by Butzel Long for fees.
Yeah, well, he actually froze my bank account, which is, talk about a place that overpromises, overcharges and underdelivers. And then they froze my bank account. So my hands are tied right here, and it's ridiculous that we're going through this right now. We're working our best. We're going to secure the property.
No, it's not. We need to find a resolution for this.
We've been trying, Your Honor, for 3 years.
I'm sorry. I agree 100%. This house needs to be sold. I ruled in your favor. One of your problems is you hired Bechtel Corporation to come in and put in your septic system when you really need to hire Joe's Septic Service, a local company, to come in and do it. I don't know how much your legal fees were from Butzel Long, but I'm sure they were substantial. They've withdrawn as your counsel. Now they're suing you, which doesn't help any of this at all because you need money to maintain this house.
So
Their
could you put,
contention
Your Honor, could I ask you to help me out with this and put a stay on that until the end of this thing? I mean, he told me.
No, I don't have the authority to do that. I'm not even sure what they've done. I regret to hear it, but this is a mess. And there's enough frustration to go around right from the very first day you got pulled out of your bed. Mr. Soltis is the fourth attorney that Miss Blair has had, and he's done by far the best job so far. He's trying to get this to the finish line too, but you're not paying the taxes. You're not paying the escrow. The house is sitting there. I don't know who's in it, what's going on with it. I've heard it is it's fallen apart. I haven't been out there to look at it. And the world has changed. Mr. Soltis is late to this, but the purchase price was $425,000, which seemed like a significant price. At that time, the market was hot, interest rates were low, and that house probably could have been sold for
it needs all new windows, Your Honor. That's $200,000.
$650,000. The house was worth more than your contract to purchase it at the time. As I said, that was not an unfair price. It was a negotiated price. I ruled in your favor for the sale of the home. But at that time, in my opinion, the home was worth more than that, maybe significantly more. Now, circumstances have changed. Somebody's built a house adjacent, blocked part of the view. The house has been unkempt for several years. It's subject to this messy lawsuit. It's got 2 tax liens on it. I don't know what it's worth now, $1. So it's different. You wish to execute the purchase of the home, and so does she. What she wanted to do. The problem is the circuit court needs to determine what your damages are. Mr. Hatch filed all these actions in circuit court that some of the things I lacked jurisdiction on, more than $25,000 in damages. I lost control of it and went to circuit court. And I don't know exactly what's happened since, although some of the pleadings talk about how long the delay is. Now, apparently there's some sort of hearing in June. But right now it's going to get foreclosed on. And that is not in anybody's interest. That ultimately may what happened to this, but I don't know who would bid on a house that has $220,000 worth of tax liens on it. And
Your Honor, with the realtors I met with the 2 of them I spoke with, local and the specialist. I mean, they told me at this point the house has been stigmatized by Miss Blair. And before this event even happened, they said this even made it worse. They said that no one would touch that property, and that they said basically it's a lot value almost right now at $400,000 unless someone wants to come in there, because it's a minimum $250 to get that place back going to normal. And it needed $150, $200 when you bought it. That's why we got the deal.
Mr. Soltis wants me to give them possession of the premises back, and he wants me to order you to pay the escrow, and he wants me to allow to use what escrow funds we have to pay the 2024 taxes.
Yeah, but he based that on misrepresenting the facts, Your Honor, about everything. I mean, he bases all that on misrepresentation. He skips over the fact that she destroyed the place the last time she had control of it. I mean, she caused so much.
I'm not prepared to give the house back to her. When she had it, it froze. All the pipes broke. The drywall had to be redone. The furnace was ruined. I don't want to do that again. And now I haven't put you under oath, but you and Ms. Bowers both represented that the utilities are paying each month. It's wonder the house hasn't. Well, I won't even say it. So there it is, sitting there pending circuit court. Now, you're not in small claims court, you're in circuit court, and district court. And there are rules of procedure and rules of evidence that have to be followed. You don't have a lawyer. I'm not being critical. I don't expect you to know this stuff. It's complicated even for me, but you're not following the rules in the circuit court where they're trying to get the matter ready for trial. I would not be surprised if this matter.
We're trying to we didn't have the documents.
Will you stop interrupting me?
Oh, sorry, Your Honor.
That's one thing. You haven't heard Mr. Soltis do it once. Attorneys are much better at following the decorum in the courtroom than lay people are. I'll give you a chance to speak. I don't want to just blurt stuff out. So you want me to just go away, essentially, and maintain the status quo of further dilapidation of this property. All right. So what do you want me to do?
Right now, Your Honor, I mean, I think that like this is harassment by Mr. Solstice because he's been bringing up, I mean, he's been misrepresenting everything about the property. I mean, he's been saying we haven't been there, we've been destroying it.
Well, I didn't ask you that. I don't think it's harassment. I think it's legitimate representation of his client. But let me ask you again.
Could you order?
What do you want me to do?
Oh, I'm sorry. Could you make an order that she pays off her tax lien and then we get clean title and then we'll purchase the property, put whatever money it is into escrow, and then once the circuit courts figure it out, then it comes back down to you and you just figure out which way it goes from the escrow.
Well, I'm not sure I even have the authority to do that, but at some point that tax lien is going to be paid off, presumably with presumptions of the sale. But let's say
that's all of our money, though, Your Honor. So we're paying it out of our own pocket. We'd be saving $6,000 a month if I could get it in my name now, or not a month. I'm sorry, a year. So that's what we pay for out of state. Because I can claim that as my primary.
So you want me to order her to pay off her tax liens and clear title to the property, and then do what? Not order that you pay any escrow pending the disposition?
Once that's done, and then we would just follow through, because then I could get something, and then all the money would just go into escrow. Once I had a clean title, I could get the money, whether I have to borrow it from the bank or private, whatever I do. I mean, get the money, and that's not an issue. I mean, but it is. I mean, I'm under serious financial hardships, but I make, okay money, so I'll get by. But I mean, and at this point, we don't know if we have the money to even redo that.
Well, for one thing, what you told me isn't evidence. It's hearsay. I don't know. I'm assuming that there's some kernel of truth in it, because I'd heard it before, that there are 2 tax liens on the property. I haven't seen any evidence to that, but let's assume for the sake of argument that that's true. You can't borrow any money to buy this house. No lender would lend you a house that you can't get title to. But in the meantime, no one's paying the taxes. I'd just let you all go, let the house go to foreclosure and have somebody buy it at a tax sale. But that's not effective. I cut your escrow payment in half. I allowed all the escrow money to be used to pay the taxes, which I thought was a legitimate use of it. I cut your escrow payment from $2,000 a month to $1,000 a month. You paid some. Now, no one's under oath. Mr. Soltis represents you paid 1. You represent you paid 5, and there are 4 or 5 unpaid at this time. But as of at least November, they're not being paid at all. And
but that's not a disrespect, rather.
Well, I don't think you did it to, poke me in the eye. I think you've got financial issues. And in the meantime, you're being sued by your earlier lawyer, who's that doesn't help at all.
No, I mean,
right.
Butzel, I would not recommend them to anybody in the world. They're terrible.
Well, I don't know what to say about that. It's got a fine reputation, but it was more of a lawyer than you needed. And my example is using a multinational construction company to do a local construction job. Plus the wheels fell off when it got stalled in circuit court. I made a ruling regarding the personal property, boats and wave runners and skis and that sort of thing. And Judge Stutzman overruled it. Mr. Hatch maintains there's a statute, which there is, which allows district courts to deal with personal property in certain circumstances, but his ruling was different to that. But we have to do something. I ordered that you pay $1,000 a month, and you're not paying $1,000 a month. That's called contempt. It's not harassment.
Your Honor.
Yes.
I mean, I don't know how to talk about a hardship here, but like what has happened in this case, you normally say the truth is in the middle somewhere. No, not in this case. It really isn't. And it's just all on her. But we spend at least $300 to $400 a month in the house just to carry it right now, just for the utilities and whatever. And that's literally every month. So that is always being paid. The property's always being, swept up, whatever. But for this hardship right now, I was expecting this to close or for them to settle this out at some point.
What you're
until
doing
we figured
right
out
now,
that she can't afford to do anything. If she took possession of the house, Your Honor, she can't even afford the gas bill. So I mean, I don't see what that accomplishes. And with all the neighbors who we've proven of conspiring against us, and Doug Coleman trying to get us evicted again last year behind your back, I think. Because how else?
Well, he's retired, so he's gone off to other things. But all right, essentially, you're living at her house without paying any rent. It's not your house. It's not her house. She has the deed. She has the title. It's her house.
What about the new furnace, Your Honor?
Excuse me?
The new furnace, the 20,000, wouldn't that be considered putting money into the house that she never put? I mean, we had to put a new furnace in there because she didn't. I mean, we've been doing everything. We've got almost 300,000 total into this house already, cash. And that's, 100,000 to Dan and those guys at Butzel. That's another 120 to Rosemary. That's another, 20 something in the furnace and stuff. And then we got another 20. I mean, it's just the numbers are just astronomical. And then we paid you guys another 40 in escrow. And then they're telling us we have to pay taxes that doubled because it's not in our name, and that she should have been paying. And then we find out she's got a $200,000 federal tax lien on her that we didn't know about. I mean, my gosh. I mean, that's why I fell over in the beginning of this case. And then they lied again and misrepresented you that she had taken care of that twice in the last, I don't know if Mr. Solstice was there, but one of her attorneys did. And then you were under the belief that she covered all that and it was all good and happy. And now it's like, I mean, everything I read through is just, none of this is factually accurate. I mean, half of the stuff that Mr. Solstice files is just, I don't know what, he's just throwing stuff at the air. That's why I feel like it's like, he's constantly coming after us. The other judge said, he's like, they're going to need an extra 2 weeks. I'm going to give it to him. And now he's coming here telling you, well, no, and he said, no, that's not what he said.
Your Honor, I respectfully but vehemently disagree. Judge Stutzman said, based upon Mr. O'Donnell's promise on January 29th, that he would get me those answers to interrogatories and documents on or before February 6th. Now, if he says 2 weeks, we're at 2 weeks now and I still don't have them. Mr. O'Donnell, I don't believe is very credible. And so, we're going to sort that out if we can eventually get the discovery that I'm asking for.
You tell me about your bill for you for a second.
Mr. O'Donnell, you're in the big leagues. You're in a circuit court case. I guess it'd be bigger as a federal. And there are rules you're supposed to follow. If you had a lawyer, Mr. Hatch was still in the case, he would have answered the interrogatories in a timely manner. But you're trying to practice law without a law license, and that's not easy to do. Mr. Soltis is representing his client. He'd also like to get this property sold, and it's in limbo.
I've reached out to him 3 times. He's never contacted me back.
All right. Now, I started to make this point earlier. You have possession of the house presently, essentially for utilities.
Whichever
When there's a dispute regarding ownership of property, the judge has the right to order that the payment be made into escrow. And the court holds on to that money till it's determined who was right or wrong. What I had hoped is ultimately these escrow funds could be applied to the purchase price that was finally determined to be, well, first of all, there's damages. You've got a claim for damages. And at some point, I was hoping your purchase price was, I don't know, $425,000 less $135 or something plus the escrow. So you owe several $100,000 to complete the purchase agreement. And my hope was the escrow funds could be used ultimately to be paid toward the purchase agreement. In the meantime,
Your Honor,
the
the original.
taxes continue. Stop interrupting me. The taxes continue to accrue. This is a non-homestead parcel of property. Taxes are very expensive. It was a valuable piece of property. And so there's a big tax bill. And I used the first portion of the escrow funds to pay the 2023 tax bill, which neither party was paying. If it's going to be your house, you should be responsible for the tax bill. If you think she should be responsible for the tax bill, then I guess you should pay some money for being there every month rather than just the utilities. So if you think the tax bill is hers, then I guess it's more her house than your house, and you should pay a monthly fee for staying there into escrow. If it's your house, as you contend, you should be paying the taxes. So it depends on which side of the coin you're on. But right now, nobody's paying them. And I don't think you stop paying this $1,000 a month out of spite. I think you don't have it. And then in the meantime, your bank account's got frozen. So that doesn't do anybody any good. Mr. Soltis, do you have a sense of how much is in the escrow? I didn't look.
Well, Your Honor, I did finally today, or yesterday rather, get a copy from the court clerk. There, as far as I can best figure out, because I don't have a total there, but if you take the amount that is in there, you don't include Mrs. Blair's $5,000 that she put in there, and so forth. You have a total of $13,571.48.
You told me that earlier.
Yep.
And there's not enough to pay the 2024 and 2025 taxes.
Correct. Sufficient to pay the 24, $9,459.82, but not the 25.
Yeah, these taxes would be half though if we were paying them.
Say that again?
I said they would be half if we were paying, Your Honor, because we'd have a homestead, so it wouldn't be even close to this number. We're being punished, double punished, and we're still paying them out of our own escrow that we're paying into. And Rosemary still maintains $120,000 she took from us originally. I mean, all the money's from us. Like, it's all one-sided, and we're paying for it. I paid for the boats to get fixed and out of storage, and she took them back or whatever. You know, I'm so like, it's just, we need to come to like, she needs to pay off her federal tax liens. Then we need to have clear title, and then we need to just figure out either close this. The dam's trial starts in June. We'll get through that. Hopefully by July that'll be over, and then bam, we're done.
I doubt that.
Well, I wish it were as simple as that. All right. How do you respond to Mr. Soltis's claim that I cut the escrow funds in half, ordered you to continue to pay at $1,000 a month, and you just stopped. So what is the effectiveness of my order if you don't comply with it because either you don't feel like it or you don't have the ability to comply with it? How do you respond to that?
Well, I respond that, well, A, it was in, it wasn't not in bad faith at all. And it was due to an extreme hardship. And at that time, Your Honor, I didn't even make a payment on anything because I was frozen in time because we got slammed with everything at one time. And it all started coming down. And then we kept on getting this new, this, that. We'd get here, then I'd get another order to go in front of you. So every time I'm preparing for you, then I get another order to go back in front of. So, we're working with, two hands tied behind my back. I'm trying my best here and I'm getting caught up. I got all the software. I got a computer now, figuring out how to get these pictures into PDFs. And then this is all going to flow a lot smoother, Your Honor. However, we've put way too much in that property. And now in the next couple of months, I got to put a bunch more money in there because I got to go up and, work on the roof again. And I got to do all the other spring maintenance up there. And I know she would never do that. And I don't have a choice. I have to do that because without that, then the house really does fall apart. But the home inspection I have from 2023 will show you how destroyed the exterior. I'm just talking the interior of the house is like, it's got
I remember all of that evidence.
And that was right after she'd left it. But now if I showed you, I downloaded them. I couldn't get them to upload to you, but I have the new pictures from last week when I was there that show new furnace, new hot water heater, nice hot place. The inside's clean, like it's all, The outside, though, it's going to look like that for a little while. And there's not much you can do unless you tear that stuff down. It's not like you can just throw like paint over it. And the guy said that the house needs all new windows. The two of the realtors went through there said all new windows. That's why they said it's pretty much lot value.
I haven't objected to all this hearsay, Your Honor. I don't believe Mr. O'Donnell at all. So,
well, he's the only one that's been lying.
I'm not going to argue in front of you about hearsay. Thank you.
Yes. Well, there's a trial set, and I regret that it's not set till next June. In fact, I'd be surprised if it even goes then. But I hope it does.
Right now, we need a little bit of a lifeline here, and I think we deserve one. After what we were put through, and you witnessed it in your courtroom on the multiple times that you let her go on contempt for nothing. And in 3 different times, fake doctor's notes, all that stuff. And now this one time, like we're really trying and we're in a bad spot here. But we've been at this for a long time and we've just gotten really run over. And now they're really putting a full court press on us and we're doing our best and we're willing, we're going to work through this. We'll be fine. We're just asking for some relief here just to get through, just till we can get this darn trial. It's like we were promised one thing and that, if they withdrew from it, they promised they'd never leave us.
Your Honor, when Miss Blair apparently didn't show up for 2 depositions, which I believe weren't properly noticed or weren't able to be properly noticed, you held her in contempt $5,000. She paid it.
That was for everybody showing up.
That was what contempt was it? Like the 5th?
All right. Mr. Soltis, it's your motion. I'll give you the final word.
Yes, Your Honor. Thank you. I guess what you're saying is you won't return Miss Blair to the owner to possession of the house. And if you won't do that, then let's move on to the money aspect of it. Tax for 2024 to avoid this house going into foreclosure, tax sale, $9,459.82. There's escrow at least, I have 5 months counting February of $1,000 a month, $5,000 that has not been paid. Miss Blair is having to pay me to ride herd on these people because they don't do what you've ordered to do. And I think that entitles me and her to have cost and attorney's fees.
All right. I am going to order that the existing escrow funds may be released to pay the 2024 taxes.
Just our mind.
Let's go back over.
I decline to relinquish possession of the property to Miss Blair because of what happened previously. I am going to allow costs and attorney fees for this motion. Do you have a bill of costs yet, or?
Not put together completely.
All right, I'll ask you to submit a bill of costs and fees with the order. I'm gonna lift the escrow requirement. And I'm gonna excuse any currently unpaid escrow funds. I do believe there are two significant tax liens on this property, which may ultimately affect Mr. Bowers and Ms. Bowers, Mr. O'Donnell's ability to even purchase it. So far, we've just been paying this money into escrow and I've been using it to pay the taxes. I guess if they're not going to be worried about the taxes, maybe I won't. But we'll get the 2024 taxes paid and they can get through 25. I would give you about a 50-50 chance of having this case tried in June, but I'm hopeful that it would go and there would be a resolution. Mr. O'Donnell, you're acting as your own lawyer. You've got a bunch of complicated claims. You've got money damage claims. You've got specific performance claims. You've got equitable claims that are only have jurisdiction of the circuit court. On the other side is Mr. Soltis, who's got 45 years of legal practice representing cases like this. And he's got to be much better and much more adept at representing his client at that damage hearing. You're not just going to show up and say, hey, shows me all this money. Right now, you can't afford to hire a lawyer. Your previous lawyer is suing you for a large sum of money. The case is an absolute mess. I appreciate Mr. Soltis getting into it in the posture it was in. But I'm not going to order you to continue to pay $1,000. I'm going to use the money I've got to pay the taxes. Mr. Soltis isn't harassing you. He's representing his client. And you stopped complying with my order that ordered you to pay $1,000 a month. So his client's calling him up and saying he's not paying the escrow payments. So he's got an obligation to his client. That's on you. Well, just excuse your obligation to pay the escrow. So you're to continue to pay the utilities and otherwise maintain the property. Put that in the order, Mr. Soltis. The defendant shall continue to pay utilities and otherwise maintain the property.
Then, Your Honor. Thank you.
You're also going to pay Mr. Soltis's cost for bringing this hearing. I don't know what it is. It'll probably be several $1,000s. But he's just doing his job.
Your Honor.
But you're going to be in front of Judge Stutzman again next week. What he's doing is discovery, which is what people do when they're involved in litigation. He wants to know what he needs to know to represent his client.
This
property had been sold back in 2023. Everybody could have been made whole. It would have had a fairly high sale price, or you could have purchased it. She could have got
Your Honor,
some equity out of it, and but now it's just a dissipated
She's
valuable
had this
asset.
lien on here the whole time. We never would have been able to purchase it.
But Your Honor, my last thing about Mr.
Well, let's
Soltis.
say you gave her $400,000 for this house and she had a $220,000 lien.
It would be taken
Well,
off at closing.
$220,000 would go to pay off the lien and she would get $180,000. So there was some equity in there for her. The problem becomes if the tax lien exceeds the value of the house. At that time, it did not. You had a purchase price at what was at that time a fair but favorable to you price. I'm no real estate appraiser, but I do know that property was very valuable at that time. Interest rates were about 1%. It was a nice home at a favorable location on a wonderful inland lake. But now it's different for a bunch of reasons. All right, so let me recap. I'm going to allow $9,459.82. No, that was 24 taxes. 945982. 25 taxes will remain unpaid. The escrow funds may pay the tax. I'm relieving your obligation to continue to pay escrow, and I've forgiven the payments you didn't make. But I am ordering that you pay Mr. Soltis's costs and attorney fees for bringing this action. He's going to prepare an order and send it to me under something called the 7-day rule. You'll get a copy of it and you have 7 days to object if there's something in it you disagree with what I said. Other than that, I'll sign it and we'll allow that escrow money to be transferred over so the property doesn't get foreclosed on. Now, the problem with that is I'm spending that money on taxes, but I don't want the property to get foreclosed on. There may be an issue about whether you get credit for that at the time if that's taken off the purchase price of the house. Because right now, all the escrow money was going to be applied to whatever was left on your purchase agreement. So in rough figures, it was $425,000 and you paid about $135,000. So that's a little less than $300,000. If you paid $50,000 in escrow, I would have allowed that money to be applied toward the purchase of the house. I'm making these rulings where I'm using tens of thousands of dollars of escrow funds to pay the taxes. That matter at some point is going to have to be resolved. But for now, that's my ruling. You still could benefit from some legal advice. I don't know who would want to get in this case. I understand you're a layperson. You're doing the best you can. You're in an untenable circumstance, but you can't just throw your hands up and ignore my order. So now we have a new order. If you don't pay Mr. Soltis's costs, there'll be another contempt hearing and there'll be another cost. And you guys can see Judge Stutzman on your discovery issues next week. But that's an order too. He told you that he gave you a deadline, you didn't meet it. He gave you a 2-week extension, you didn't meet it. You're going to have
It was
to
an
at some
impossibility,
point.
Your Honor. We just got the files on Monday. From the bus alone,
Well,
we just
explain
got the files on
it to
Monday.
him. All right, Mr. Soltis, anything further we need here?
No, Your Honor. I'll prepare the order 7-day rule.
All right, thank you.
One more question, Your Honor.
Yes.
And under the 7-day rule, I mean, just because in his, contempt order, I mean, he didn't do his homework because today he sat to you and told you a whole different story than is written down here. Counts 2, 3, 4, 5. I mean, he just changed his whole tune. So, I mean, it's like he's just submitting whatever he wants. And then he goes in there and then just, well, let me clarify. I mean, he did that in front of Judge Stutzman. So that's how I feel like I'm being like I'm just.
You're shooting at the wrong target. I just gave you a huge bunch of consideration and you're complaining because you don't understand the pleadings. You're going to get blown out of the water in the circuit court unless you figure out what you're doing. But I don't want to hear it. You pay his fees.
That's fine.
All right, you're good to go.
Thank you, Your Honor.
Thank you.
You're shooting at the wrong target. He just gave you a whole bunch of consideration, and you're just spitting in his face, basically. Ladies and gentlemen, oh my goodness. I watched that live today, and it absolutely drove me batty. Let me get my mic a little bit closer to me. I want to tell you, tomorrow, there's another one, and it's worse. It's worse than that. So prepare yourselves. For Valentine's Day, I bring you a 3-hour Judge Middleton maddening case that involves an old guy who refuses to leave the apartment that he's been evicted from. He is evicted. The apartment is actually condemned. No human can live in it. Not even him. But he refuses to listen to anybody. He's been taken to jail. He's been taken to the hospital. He checks himself out of the hospital. The apartment's full of bed bugs. We're going to hear from witnesses. We're going to hear from bug specialists. We're going to see pictures. We're going to get it all. So for tomorrow, ladies and gentlemen, I'm not giving you flowers and sweets. I'm giving you sours and beets. I don't know. Whatever I'm giving you, it's done. It's cut. It's put together. We're ready to go. All I got to do is make the link and get the thumbnail up there for you. But man, what little bit I saw of it, it was something. So make sure you tune in tomorrow. That is 11 a.m. Central Time, noon Eastern. Brunch for the weekend review on Saturday. We do it every Saturday, if you don't know. And I am not going to give you fortunately, you don't get the bed bugs by just hearing about the bed bug stories. So, but I want you to have a good nighty night. Don't let the bed bugs bite, because, you know, that's what they say and all. Ladies and gentlemen, I am your lone wolf Usul. I am your humble host, and I am your curator for these here crazy court videos that teach us all a little bit about each other and serve to engage the educational side of our brains so that we may not behave the way some of these people behave in court. Here's looking at you, pro se guy who's out of your league in circuit court, and Mr. Trucker versus Troopers. I don't know, man. I get it. You got your trucks governed. You're technically, physically speaking, the truck's not supposed to be able to go longer. But you know, things happen. I do want to say a very, very special thank you to Charlene and Julie for their wonderful contributions to the stream. And ladies and gentlemen, thank you so very much for hanging out with me. I'm your humble lone wolf Usul, and I will see you next time, which is in about 13 hours from now. But for now, I am out. I'm not wasting any time. I'm kind of tired, and we're getting it done. I'll see you. I'll see you in about 12 hours, something like that. Look, come by. This 3-hour Middleton landlord-tenant case is crazy. It's worth the watch. But for now, get out of here. Go get. Scoot. Bye.